sure. Yes. She's taking a picture of here. We're gonna make believe. What are they gonna do? Hey, bro. I would like to point out that he played shortstop. He was the pitcher. And let me tell you, when Legal Aid played
Good morning, everyone. My name is Margie Russell, and I'm the Executive Director of NYARM. Thank you for joining us here this morning. Our topic is how to conduct meetings, whether it's board meetings, annual meetings, shareholder meetings. The moderator is Jay Hack, who is a partner with Gallup, Dreyer, and Berkey. I'm going to let him introduce the subject further. During the presentation, if you have questions, we're hoping you'll hold them until the end of the presentation. There's a mic over there, so you can get your question hardwired into the video. We do film everything, and you can announce your company as well. And I hope you come up with intelligent questions so you show well on the video. You can also use the mic over there. So, Jay, it's all yours.
Otherwise, you'll be edited out.
That's right.
Absolutely. And if you really want to ask a question, you feel compelled to ask a question during the presentation, raise your hand. I'll call on you and I'll repeat the question into the microphone. Now, what we're going to do today is, as Margie said, is we're going to talk about meetings. What she's done is she's put together a panel of 5 lawyers who are going to present to you over the course of the next hour and 45 minutes somewhere probably between $2,000 and $3,000 worth of billable legal time, so take advantage of it. I'm not going to waste your time with lengthy introductions. We'll just say that our 4 panelists are to the right, my far right, your far left is Ron Scher, firm of Himmelfarb and Scher in White Plains, New York. He fairly characterizes the dean of the Westchester Co-op and Condo Bar. He has been doing that kind of work since late 1978, early 1979, I believe.
Unfortunately, yes.
Yes. It's okay. I think we're exactly the same age. We used to play on the same softball team together years ago. His firm, as do all of these gentlemen, handle a wide variety of real estate matters with some significant focus in cooperatives and condominiums. We have Steve Wagner from the firm of Wagner and Burkow, a recently formed firm, but he has an equal amount of experience at other places as you do a lot of he does a lot of litigation. He's the evil tenant side. I'm sorry I didn't say that. Then we have Steve Kirkpatrick, who is at the firm of I'm sorry, I got it mixed up. He's at Belkin, Burden, Wenigan, Goldman. He is, however, on the the landlord side. Then we have, last but not least, we have Scott Greenspun from Braverman and Greenspun on an issue that is going to be one of the key points of what we're talking about, which is shareholder access to board minutes. We've parsed the discussion into 4 parts. Ron will first talk about director meetings. Then Scott will talk about stockholder meetings. Steve will discuss general issues that transcend both. And then Steve Kirkpatrick will talk about and what goes wrong. He'll tell the horror story side. I'm going to moderate. I just want to give you one thought before we start, and that is, let's call it the geek thought. I'm kind of a geek or egghead on these subjects. We're talking about stockholder meetings and we're talking about director meetings. I want to explain one fundamental difference that causes a lot of people to get mixed up as to who's got what rights in what kind of meeting. And that is, think about what those 2 things are. You have a director meeting. Who are directors? They are representatives of other people. They owe fiduciary duties. They are elected by other people, and they have to discharge those duties. Stockholders are different. They own stock. They represent themselves. They are themselves. they have different kinds of responsibilities. So the easy example, I hope I'm not stealing from somebody, is...
You are, Jay.
Am I stealing? It's all right. I said we've known we played on the same softball team. It's okay. There's a fundamental difference between the two. Directors owe duties to companies. They owe duty to, in a co-op, to the co-op. A board of managers of a condo, technically not, although it can in some cases, but generally not a corporation, but courts think that they're similar. They owe duties to their owners. They owe duties to the entity, the condominium, or the cooperative. Stockholders, they owe duty to themselves, and that creates a lot of differences in terms of the two. And when you wonder why can stockholders give proxies and directors can't give proxies, think about that concept. That's all I have to say. I'll turn it over to Ron. Ron, please do not trip over any of the wires. We'll be fine. Materials.
Make us look at it.
Here, you
Handouts. Good morning. My name is Ronald Scher, Himmelfarb and Scher. We represent buildings, co-op and condominiums all over the metropolitan area. At whatever anybody does at night, as you know, we're sitting in a board meeting under asbestos-wrapped pipes, dealing with the issues we want to talk about: governance, mortgage refinancing, capital improvement projects, when the board of lay people who are running $1 million corporation want to talk about dog barking, noise complaints, and odors. So we're here to talk about the primer, the ABCs of conducting a meeting. For 36 years I've been doing this, and I go to meetings, and some meetings I love to go to. The boards are great, the thing works perfectly, it's a fine-tuned machine. Some are disasters, some are dysfunctional groups of people that cannot get along. I once went to a board meeting where the sponsor directors moved at each meeting that all directors should resign and have a special meeting to elect new directors. So we're here to talk about what works, what doesn't work, and this is the who, what, when, where, and how show. So who are we? The board of directors. What are we doing? We're learning how to conduct the meeting. Many of you do it yourselves. You watch people do it. And where is the meeting conducted? Generally, it's conducted at the location set forth in the bylaws for the principal office or any other place designated in your notice. But where is it actually conducted? As I tell all my boards, whatever borough, whatever city you're in, you should always consider yourself in Las Vegas, because what happens in a board meeting should stay in a board meeting. There should be some expectation of confidentiality. You should be able, as a board member, to know what you say there is not going to be reported, and you're not going to be accosted by a hostile shareholder who wants to know why you voted against their request to have some type of request for a sale, some type of request for windows or some alteration. So just as a chain is only as strong as its weakest link, a board meeting is only as civil as its most disruptive board member. It's only as in control as its most boisterous member, and it's only as productive as its least productive director. So you need to have what I call the 2, 4, and 7 rule. 2, good governance. 4 is the 4 C's: communication, civility, cooperation, and control. And the 7 P's: proper prior preparation prevents, I won't say one of the P's, but it's poor performance. You need to be prepared. You need to be on time. I hate to go to meetings where people are coming in half hour late. Set a meeting, be on time, and be prepared. So I'm going to jump around here because we have 4 people who are going to be talking about different topics, and then we can go back. But some of the issues that we wanted to say is, who controls the meeting? Who calls the meeting to order? When is it called to order? Well, it's called to order when a quorum is present. Quorum is present is the majority of your board. The majority of your board, let's assume, is 7 people. 4 people can call a quorum. Quorum is present. And then a majority of them can put in and activate and operate the business. So you can have approximately 25% of your total board make a decision if a quorum is present and that majority votes in favor of something. So if you have 5 people present on a 7-person board, 3 people can enact that operation and that business, depending upon if the bylaws provide for something else. So I'm going to go to the most important thing. Emails. Emails have now taken over board business. Is there voting by email permitted? No, it's not permitted. It's not permitted because you can't be participant in an email conversation. You should not vote by email. If you do it, which happens all the time, it should be unanimous. It shouldn't be something that is something that's substantial or is a lot of money. And if you're going to do it against your attorney's advice, you better make sure that that action is ratified at the next board meeting and the minutes reflect that. Minutes. Who takes the minutes? Sometimes it's the managing agent, sometimes it's the secretary, but the minutes are not a verbatim discussion. They're not even a summary of what was said. Minutes are what happened at the meeting. The rule is minutes are what happened. What was this, not what was discussed, but what happened. Minutes should be vanilla. I don't want to read minutes that say, and I get sent minutes to review all the time. Thereafter, the board requested the managing agent to conduct an inspection of the steps that everybody felt was dangerous and unsafe. I don't want that in minutes. At the least, the best it should say is the board requested the managing agent conduct an inspection of the steps. I don't need to put out to the world that we acknowledge for everybody that there is a problem that's unsafe and dangerous. Minutes should really be what you produced. Thereafter, the board discussed this issue. They voted to table it. They voted to approve it. They asked for something to be done. Minutes are something that can be read. You can be hoisted by your own petard. As they say in criminal law, what you say can and will be used against you in a court of law. Those minutes are discoverable. Talking about discovery, emails are discovery. They can be discovered in litigation that some people will be talking about. Be careful what you email. You don't want to have it read in a court of law in what you say, especially in discrimination cases against board members. The conference call. Can you participate in a board meeting via conference calls? Is there a protocol? Yes, you can. You can participate, and there is proceedings that you can put in and approve conference calls where there's a speakerphone that permits everybody to hear and participate. That's the key critical issue. So one board member said, well, we want to all be part of Skype. Can we do that? If you approve it and put it in your bylaws as a protocol, you can all be part of Skype as long as everybody can participate. That's why having one-way conversations is not really effective or permitted. It's not correct. You can't have that. Nor, most importantly, can you vote by proxy at a board meeting. You are elected, people are elected as board members, and they hold a fiduciary duty. They have a fiduciary responsibility to act in the best interest of that corporate entity. Therefore, they are not permitted to assign their rights to another director. They're not permitted to vote by absentee ballot. It's not correct. Does it happen? It does happen. But it should not happen. And if anything like that does happen, the minutes in the next meeting should be ratified that that action was done. Yes, Jay?
What happens, what, can you poll the board? What happens if you want to vote something, you want to adopt a resolution? Can the managing agent call all the board members and have them vote on it?
The answer is no. Can it happen? It happens all the time. You have different polling. It happens. It's not proper. It's not the protocol that should be followed. But at the next board meeting, it should in fact be ratified in the minutes to reflect that it was approved, especially if it's significant. If it's something where the board approved a purchaser, I don't really care that much about it. If they rejected a purchaser, I'm very concerned about it. I don't want anything rejected via email, via independent voting. I want it all done so that you are protected. It's Proper prior preparation also protects board members. So you have before you a brief seminar of the pitfalls, the do's and don'ts, serving on a board. No good deed goes unpunished. Minutes, quorums, executive committees. I like before, right after the annual meeting for a building, the election of the board, the appointment of the officers, I like that board to appoint an executive committee comprised of at least 3 directors so that they can act in the stead of a board and with only 3 people present, as opposed to a 7-person board where you need 4 people present. I like an executive committee. Most bylaws provide for that enabling power so that they have the ability to act. Executive committee meetings should also be, you should also take minutes on. Who let the dogs out? The bylaws, are they more bark than bite? They do bark a lot, and they can bite you. You have to be careful. Every bylaw is different. Proprietary leases are different. You should read them. You are professionals. You presume that most of the proprietary leases is only really three in existence that everybody used, but they're a lot different. There's some little differences that you need to look at and be comfortable with. So the conducting of the meeting, the board's duties pursuant to their fiduciary relationship is the C, to scrutinize, examine, and evaluate the governance issues and navigate the topics and the areas of concern presented in the agenda. Who controls the agenda? You know, it's an interesting thing. You guys, as managing agents, prepare agendas. Maybe. You should, I hope, because you want to control what happens there. Whoever's in control of the agenda sets the tone. Sometimes you and the president. There will be board members, they'll be sending in things. I want that on the agenda. Now, hopefully, most of your meetings are not dysfunctional. There aren't fights between directors. There isn't disputes or arguments. I've had board members that have sued over water damage, and they wanted to stay in the meeting while the board discussed their settlement. And what's the procedure for a conflict at that point in time? I think that you should have some type of protocol set in. If there is a conflict, that board member should then be able to make a presentation and then excuse themselves. You should set up that protocol as opposed to them demanding to be present during the meeting and then demanding to see those minutes of what the settlement was, since directors are entitled to see all the records. It's an interesting thing that you can discuss. Hopefully you'll never have to face that. So the meeting is called to order based upon the quorum, which we discussed. The agenda is set. The board president should monitor, set it. He's the chief, he or she is the CEO, runs the meeting, presides over it, and then review and approval of minutes. The minutes, it's what the majority says is what the minutes are approved as. If people are objecting and I've been to meetings where people are fighting over minutes. I didn't say that, this should be here, this should be different. If the majority say the minutes are what they are, then that's what they are, and move on. Don't go back. If a director wants to fight about them, let them send a letter to the secretary to say, I oppose those minutes, or I differ, but the minutes are what they are. And minutes are read, and they're read by people in litigation, and they're also read by strangers. Sometimes boards do not allow minutes to be read by their own shareholders, but they do allow, most of the time, minutes to be read by strangers. Prospective lawyers, prospective purchasers, lawyers get to read the minutes. It's just it's a funny anomaly. It's a paradox that we let those people read it, but we don't let our own shareholders read it. There's no right or wrong to that as well. The notice of meeting. Neither the business to be conducted or the purpose of the meeting need to be specified in a regular board meeting notice. You can set a meeting date to say the third Thursday of every month. You need not have a notice of meeting. Can you have notices sent by emails? I think you can. I recommend that you just change your bylaw. It's an easy amendment to put in email notices. The amendment to the bylaws, most of the time, those little points can be amended just by the board, by 2/3 vote of the board, without the intervention of the shareholders. As I said, voting by proxy is not permitted. Abstention voting. It's an interesting, strange fact. If you have a 7-person board, 5 people are present, you need 3 of those people to vote in favor of something. 2 people abstain. So you have 3 people voting, 2 in favor, 1 opposed. Some people say, well, the abstentions are like they weren't even present. So you have 2 in favor, 1 opposed, it passes. That's not true. Abstentions generally count as no votes. They're a no vote. If somebody abstains, they should just as easily set a no vote, because that's what it will count as, because you need the majority. We're talking generally. You need the majority of the board members present. Some bylaws will require 2/3 for certain things or a different type of vote, but at this time, participation in the meeting. What happens if there's a dispute, an argument? Who is the referee? You as the managing agent, stand up, civility, you blow your whistle, you say stop. How do you stop board members from fighting? The disagreeable ones, people who are not being civil. The board president should carry a big stick, a gavel, some type of thing he could or she could use. If you have a disaster for a board member, you can warn them. You can ask them to be quiet. You can tell them if they don't be quiet, you will ask them to leave. You could then adjourn the meeting. I have had boards where if you have a person who is not a participant, who is argumentative, who is really dysfunctional, and they are an officer, you can have them removed as an officer, and then you could have an executive session or executive committee without them and go into executive session to try not to conduct business without them present. So at this time, I've taken up a lot of time. I'm going to go on and let the other people go. I've given you a code of ethics for directors from the National Association of Co-ops. You will see that here. I like to give it to directors. I like them to sign it and acknowledge it right after the annual meeting. I like them to also see what their duties are. We could talk about many other things. Can interested directors vote, things like that, but I'm going to let my compadres go on. Thank you.
Just to add one thing to what Ron, or to supplement something Ron said, he mentioned executive committees and executive sessions. I'll tell you the ultimate horror story, and it wasn't a co-op, but it's an important lesson to learn, and we advise a lot of co-ops to do this. I represented a bank upstate, and they had a director, and the director had a habit of drinking a little bit too much and talking too much about bank business at the local bar. There was a major real estate transaction, and the bank wanted to do the lending on the transaction. The owner of the property would not come to that bank because he knew that the board was going to discuss his loan, and he knew that that director was going to get drunk and talk about it throughout all over the town, and he refused to come. And what did we do? We actually created a special committee. We could have thrown him off, but they didn't want to do that. He'd been around a long time, well-known guy in the community. We created a special committee of the board, and all of the board members except for that director were members of the committee. And we told the particular owner that the committee would make all decisions and have all discussions with respect to that matter. And that particular director that he didn't like and he was worried about would know nothing about the loan transaction. He was satisfied. The committee was formed. The committee made all the decisions. The director didn't know. He knew that there was going to be a loan. He didn't know anything about the director's personal financials, the business financials, or anything else, and everything went fine. Which I mean, Ron hinted at that during his presentation. If you have a disruptive director, one thing that we do, and I'm sure all these gentlemen do, is we advise boards that you can insulate that person from the decision-making process by forming a special committee. And we just had a case decided last week where the court approved exactly that, because we had one director who disagreed with a litigation posture and had a bad habit of going to the lawyer on the other side and telling them what the board's litigation strategy was going to be. We got an injunction against the person speaking, and we isolated them by having a special litigation committee that had 11 out of 12 board members. And you can do that if you need to. So now let's move on. We will go, let's see, who's next? I'm sorry. Next is Scott on stockholder meetings.
Can we go this way?
Yeah, you
You
go.
have no wires.
I have no worries.
We have wires. Good morning, everybody. I'm Scott Greenspun from Braverman Greenspun, and I'm going to talk about annual meetings. Most of you have probably been to more annual meetings than we have been to. And I'm going to try to give you some takeaways that will either give you some knowledge about things that you didn't know, or maybe give you some information that will help you resolve an issue that you may face in dealing with an annual meeting. As you also know, the Bible for an annual meeting are going to be the governing documents. The governing documents are going to set forth all of the information that you're going to need to conduct the annual meeting. When an issue is not addressed in your bylaws, you call one of us. But if you want to try to find an answer to a question that's not addressed in your bylaws, and you are representing a co-op, look to the business corporation law. I find it amazing that sometimes even the most minute or obscure questions are answered in the BCL. For example, let's say you're presiding over a large building's annual meeting. There are lots of shareholders. Husband and wife walk in together. The husband's sitting with his friends. The wife is sitting with her friends. And then you give out the ballots. And they fill out their ballots, and they vote differently. What do you do? The answer is not going to be in the bylaws, it's not going to be in the lease, and it's not going to be in the declaration. But remarkably, that answer is in the BCL. I'm going to keep you in suspense and give you the answer a little later. Also, while the courts and the business corporation law give the board great latitude in making decisions and running annual meetings, the BCL in many instances sets forth minimal requirements. So for example, in setting a record date for shareholders to determine when they have the right to vote, the BCL says that the board can make that determination, but it has to be no more than 60 days before the meeting or no less than 10 days before the meeting. Also keep in mind the distinction between co-ops and condominiums. In almost all instances, condominiums are not corporations. They're unincorporated associations. And typically, condominium bylaws are going to have much greater specificity on how an annual meeting is supposed to be run. But if the answer to an issue or problem that you have is not within the condominium's bylaws, courts and most practitioners are going to go to look to the BCL by analogy to find the answer to that question. I have a checklist of things that I would suggest that you bring to an annual meeting, particularly if you're going to have a contested or divisive election. Make sure that you bring a copy of the governing documents, have a copy of the lease, have a copy of the declaration, have a copy of the bylaws. Also, bring the certificate of incorporation. Very, very often, if you don't have an answer to an issue in your bylaws and you refer to the BCL then refers you to the certificate of incorporation. Also have a copy of last year's minutes. 99 times out of 100, you're not going to have to read them, but be prepared in case you do. Have your notice of meeting. Make sure that you have an affidavit that it was served on all of the shareholders or the unit owners. Make sure also, particularly if you're going to have a contested election and you have a co-op, have a certified list of everyone that is entitled to vote as of the record date. That is presumptive. Nobody can challenge that. So if there's an issue as to who can vote or who can't vote at a meeting, if you have a certified list, which indicates all the shareholders who own shares as of the record date set by the board, that will be the beginning and the end of any dispute. Make sure that you have an oath for the inspectors if you're going to have one. And also, when preparing ballots, make sure that you leave blank spaces on the ballot in the event that you have some nominations to the floor. Some of the biggest objections that we get in contested elections, or when you have individuals that decide they want to run at the meeting, was that the ballot was unfair because there wasn't a space for their name. In terms of giving notices for the meeting, you all know that you must give the notice within 10 days of the meeting, no more than 60. You can, if authorized by your bylaws, give notices by email. The BCL authorizes that. But in most instances, it's not authorized within your bylaws. So, as was suggested earlier, get your bylaws amended to make sure that you can give board minutes by email, and also it would make your life a lot easier and a lot less expensive and expedient if you could give notices of annual meeting also by email. If you have a meeting that is adjourned and you adjourn it to a specific date at the annual meeting, you do not need to give an additional notice. You can, and that's going to be up to the board. If you have an annual meeting that is adjourned to a particular date and then it's adjourned again to a subsequent date, then you must give another notice of that annual meeting. Who is entitled to vote at the annual meeting? That is an important issue when you have sponsor and commercial unit owners. Know before the annual meeting what the sponsor's rights are, if they still own any units, and the commercial unit owner's rights to vote and to appoint directors to the board. That often becomes the most divisive issue at a meeting. So know how many units the sponsor still owns. Look at the governing documents to see who can they appoint, who can they not appoint. Can the commercial unit owner vote? Can the commercial unit owner appoint members to the board? Know that in advance of the meeting. It'll make your meeting run much smoother. The answer to the question before as to what you do when you have multiple ballots filled out by individuals who jointly own a unit. If you have multiple owners of an apartment and only one of those owners vote, it is presumed that that voter is voting for everybody. And you don't need to have everybody who owns a unit sign on to a ballot. If you have a husband and wife, brother and sister, two different owners of an apartment, and they both vote, and their votes are not consistent, you divide their votes proportionally. If there are three owners of an apartment, you do it by them, and the three of them submit ballots. You do it by the majority. Proxies. Always an important issue at annual meetings. Proxies are valid for 11 months. You do not need to wait for the board to instruct the managing agents to send out the annual meeting package with the proxy to start soliciting proxies. The board and or minority unit owners or apartment owners can start soliciting proxies months in advance, up to 11 months in advance of an annual meeting, because proxies are good for 11 months. Also, a proxy does not have to be in the form that's disseminated from your offices. It can be any form. You don't need an original signature. It's any document that indicates the intention of an owner of an apartment to give their right to vote to someone else. And as a matter of fact, unless there is specificity within your bylaws, the BCL, in some instances, may even permit an email from a unit owner to another unit owner indicating their desire that someone act as a proxy to be sufficient evidence for the proxy holder to vote. It's going to depend on the language of your bylaws, and it's going to depend on whether the inspectors of the election or the attorney and the board believe that the document sufficiently indicates the intent of the owner of the apartment to have someone else act as their proxy holder. In most instances, in order to conduct a meeting, you need to have a quorum, which is a majority of the shareholders or the majority of those persons owning more than 50% of the common interest. However, if it's provided for in the certificate of incorporation, it can be as little as 1/3. So you need to check the certificate of incorporation and confirm that that certificate doesn't provide for less than 50%. If you start a meeting with a quorum and some shareholders and unit owners leave after the meeting starts, the quorum is not broken. The question I get asked often when I'm sitting at an annual meeting is, when should we start? It's 5 minutes after, 10 minutes after, 15 minutes after the date stated in the notice of meeting, and there's still not a quorum. What I usually recommend is start your meeting. Start it as an informational meeting. Make sure that the unit owners and the shareholders know that you cannot conduct any official business. In many instances, as the board is giving its presentation, there tends to be a trickle-in of people who will then give a quorum to the meeting, and then you can go ahead and you can have your vote. Another topic that often creates some issues are inspectors of election. Unless required in the bylaws, you do not have to have inspectors of election. And typically, the bylaws of a condo or corporation are not entirely clear. In almost all condominium bylaws, you will have the agenda for the meeting set forth in the bylaws. And one of the things mentioned in the agenda is inspector of elections, in parentheses, if required. When is it required? It's required if a majority of the persons at the annual meeting want it, vote for it, require it. Typically, I would advise boards to have inspectors of elections when you're going to have a contested election. How many inspectors of election? The BCL and bylaws typically don't say. When you're going to have a contested election, I like to have 3 individuals. Those individuals are appointed by the board. They are not voted on by the unit owners or the shareholders. And when you're going to have a contested election, that's an issue that I like to have the managing agent and the board discuss in advance of the meeting. I typically like to have 3 individuals, one of whom is going to be aligned with the board, another individual who's going to be aligned with the opposition, and then I'd ask the board to try to find someone who is respected within their community of shareholders so that you'd have an elimination of issues of bias when the votes are counted. I guess one of the other big issues, and maybe most hotly contested issues in dealing with a meeting, is question and answer time, and when are people going to be permitted to ask questions? how long they're going to be allowed to speak at the meeting. And the advice that I was given when I started working for Ed Braverman 20 plus years ago is that you don't allow questions and answers until after you have the election, because it speeds up the election, it gets the election moving, it gets the shareholders, the unit owners, in and out of the meeting quickly. And that advice in many instances works, but when you have divisive issues or contested election, it's not always practical. When you have issues facing a building, the shareholders, the unit owners want to ask questions of the board while they're giving their presentations. If the board tries to squelch questions during the presentations, it often results in the impression that the board is insular, that the board is trying to hide something. You have to remember that the annual meeting is the one chance that the owners of the apartments get together and are able to hear what the board has to say, discuss important issues, and ask questions of the board. And I think that you have to draw a balance between moving the meeting along and not have it be a 4-hour adventure, and also allowing the owners of the apartments to find out what's going on in their building. If you know that you're going to have hotly contested issues, divisive issues, a contested election, the best thing to do is decide how you're going to handle questions and answers before you start the meeting. One of the things that I'll suggest is set a time parameter, that you allow the board to give its presentation and then tell the unit owners, the apartment owners, that you're going to have 15 minutes, 20 minutes, a half an hour of questions and answers. Also, another alternative is that when you're having a board election and it's going to be contested, very often the candidates are going to give a presentation. You can also include question and answer time within the time that you're going to give candidates to make their presentations. You can give each candidate, for example, 2, 3, 4, 5 minutes to speak, which will also include time for an introduction and answering of any questions. Thank you very much.
Couple of quick comments. An interesting anomaly between what Ron said and what Scott said, and they're both right. Ron pointed out that when a board votes, if you have 2 abstentions, they count as no votes. When you have a stockholders meeting and you have abstentions, they do not count as votes. And that's what the law says in New York. It's actually an interesting anomaly between New York law and Delaware law. In New York law, a vote of the stockholders is determined by the votes cast at the meeting, and an abstention isn't a vote cast. So therefore, although the board can't vote 2 to 1 with 2 abstentions and approve something if there are 7 members of the board, stockholders can. And that goes back to the whole idea I mentioned at the beginning about fiduciary duties, and directors represent the people. And the law provides that you got to have a majority of the people represented to be sure that the board can act. But when it comes to the people themselves, they don't show up, too bad. They owe a duty to themselves and no one else. And if they don't show up or they don't vote, they don't count.